or a woman or a crime is in the courts and not the canal in the courts.
Late this summer, my fitness to continue in office came under attack when accusations against me, made in the course of a grand jury investigation, were improperly and unconscionably leaked in detail to the news media. I might add that the attacks were increased by daily publication of the wildest rumor and speculation, much of it bearing no resemblance to the information being given the prosecutors. All this was done with full knowledge that it was prejudicial to my civil rights. The news media editorially deplored these violations of the traditional secrecy of such investigations. But at the same time, many of the most prestigious of them were ignoring their own counsel by publishing every leak they could get their hands on.
If we have a public figure who is exercising his public responsibilities in office, he has to expect that there will be full and vigorous reporting going on about his activities.
The Constitution doesn't differentiate between any defendant, no matter what kind of position that he comes from. He's entitled to constitutional protections that are involved.
I don't think there's an answer to the question of what a free press or a fair trial. I think they're both critically important, and I would hope that in each individual case, people of good sense and cool heads would try to work things out.
The case of the United States versus Agnew have unanswered questions for journalists and jurists alike. The courts are well equipped to insulate the average defendant from undue or prejudicial publicity. But when the defendant or would-be defendant is a man in high office, the public's right to know about his activities comes into play. For the court, the question is a matter of guaranteeing the Sixth Amendment right to a fair trial. For the press, the question is largely a matter of standards, what to print and what not to print.
The standard is that journalists in a free society operating in the interest of a free press are obliged to do their best to learn the truth and then to tell it, and not to get caught up in non-journalistic concerns, whether it's going to do this interest or that interest any harm.
One of the terribly unfortunate consequences of recent events is that the press often seems to feel that it is entitled to entire freedom and doesn't feel obligated to handle its freedom by restraining itself. There's kind of a generalized feeling that the more information, the better, regardless of the consequences. But if they hold to that position, that will force countervailing pressures from other institutions to rein them in.
In the Agnew case, the countervailing pressures took the form of subpoena power granted by a federal judge to Agnew's lawyers.
Our plan was to ask the newsmen only these questions, showing the particular reporter an article. Did you write this article? Are the statements in the article true? Here in the article where you say that your source was a high Justice Department source or a high government source, is that statement true? We expected that we'd get affirmative answers to those questions, and at that point we expected to stop. We would have made out what lawyers call a prima facie case. We would have made a showing that there had been leaks, deliberate leaks, by high government or Justice Department functionaries.
There's every indication from the subpoenas that the questioning would have gone far beyond the narrow limits Topkis outlined. But before the reporters had their day in court, Agnew resigned and pleaded nolo contendere to a federal income tax charge. Under judicial guidelines set up in the late 1960s, attorneys and other officers of the courts may be disciplined for feeding the press prejudicial information. In the Agnew case, the court's own system for protecting the man under investigation failed, and the court turned on the press. It wasn't the first time that's happened, and it won't be the last. Today's concern over the fair trial, free press issue dates back to the Bruno Hauptmann trial in the 1930s. The sensational trial for the kidnapped slaying of the Lindbergh baby attracted over 200 newsmen to the small town of Flemington, New Jersey. Hauptmann's criminal record was widely published. Newsreel cameras were installed in the courtroom, where the public regularly applauded state witnesses. When the issue of prejudicial publicity was raised on appeal, the court ruled that it was inevitable in such a case. Responsible lawyers and journalists disagreed, and the issue became a topic of concern. Traditionally, the courts have assumed the major responsibility for combating the effects of undue trial publicity. Careful screening of jurors is the first remedy. Judges may also move or delay cases. In some instances, when the courts have thought it necessary, the press has been cited for contempt. In the late 1950s, the Supreme Court began setting aside convictions on the grounds of publicity. In 1965, the case of Billy Saul Estes, convicted of swindling in Texas, became a landmark. The Supreme Court reversed one of Estes' convictions on the grounds that televised court hearings had prejudiced the case. The court added that no isolatable prejudice could be shown. In other words, the justices based their ruling on the hunch that televised hearings had damaged Estes' rights.
I refuse to answer the question on the ground that it might tend to incriminate me, sir.
In 1954, Dr. Sam Shepard, a Cleveland osteopath, was tried for the murder of his wife. It was one of the most sensational trials in recent times.
We, the jury in this case, being duly impaneled and sworn, do find the defendant, Sam H. Shepard, not guilty of murder in the first degree, but guilty of murder in the second degree.
12 years later, a Supreme Court reversed the decision. In their ruling, the justices made a number of specific suggestions for dealing with the circus atmosphere that they said had surrounded the Shepard trial. One of these suggestions was that the number of newsmen allowed to attend a trial be limited.
Police Captain Will Fritz preceding.
Many of today's guidelines for trial coverage stem from the 1963 killing of Lee Harvey Oswald.
You'll see the shooting occur very shortly. There comes the man from the right. Watch him. He walks up. He fires the gun. Oswald slumps to the floor. And then, of course, complete delirium and pandemonium breaks out. Cameramen and all getting pushed, shoved aside as the police immediately rushed to Jack Ruby, also rushed to Lee Oswald.
The Warren Commission report on the death of John F. Kennedy took the press to task for its excessive coverage of the assassination. The coverage, the commission said, was a factor in Oswald's shooting by Jack Ruby, a Dallas nightclub owner. In response to the commission's findings, the American Bar Association set up the Reardon Committee. The three-year study group issued a set of recommendations in 1967. Former New York State Supreme Court Judge Bernard Meyer was a member of that committee.
I think that the answer to the question of where are we going is that we're in a much more cooperative direction than we ever have before.
Cooperation is one thing, but a sensational crime story is another. A case in point, last summer's mass murders in Houston.
Henley says he and two other young people were intended victims Wednesday morning. They had passed out at Coral's house after an all-night party.
I woke up and he was clamping handcuffs on me. I was laying on my stomach. The other two were on their stomach and they were handcuffed and their feet were tied. I can't remember whether he tied my feet afterwards or they were tied when I woke up.
How did you get on the handcuffs?
I told him I'd do anything he wanted. I'd kill him. I'd torture him if he'd let me go.
Henley says Coral let him loose, but then instead of killing the others, Henley says he turned the gun on Coral and shot him repeatedly. Then he called police and led them to the graves. The late afternoon digging continued into the night. Bodies had been uncovered and possibly more were in the dirt floor. A stripped car was pulled from the shed and the digging started where it was parked. There were more bodies. All were young boys, early to mid-teens. Each had his hands tied and the bodies were wrapped either fully or partially in plastic. Lime had been spread in the graves to help destroy the remains. As the night progressed, the digging continued. And as the digging continued, more and more bodies were uncovered. Some of these victims were probably killed as recent as 2 months ago. Others had been missing as long as 3 years. One was the cousin of a Houston homicide detective, and possibly death had come as a welcome relief for all of them. Lawmen are certain each had been tortured. That's another body. It's almost incredible. The more they dug, the more skeletal remains were turned up. And the question was asked over and over again, just how many are buried at this gravesite? Larry Connors, Eyewitness News.
By the time the digging stopped, some 27 bodies had been uncovered. The number of victims, their youth, and the grisly nature of the crime made headlines in newspapers across the nation. The state contends that the murders were committed by a 33-year-old candy maker, Dean Corll, with the help of two teenagers, Elmer Wayne Henley, 17, and David Brooks, 18. Corll is dead. Henley and Brooks are charged with several counts of murder. The story broke with the filmed confession by Elmer Wayne Henley that he killed Corll. It was broadcast by Houston station KPRC and picked up by NBC Network News. The man who talked Henley into letting his confession be filmed is Jack Cato, a Houston television reporter.
When I got there, the two police officers had been with Henley most of the day. The two Houston officers had been with him for about 2 hours. They'd worked up a relationship with him where they wanted him to tell them as much as he could about what had happened. There was no phone at the boathouse. There was no place he could call, so the logical thing was, well, use the car phone. And he wanted to call his mother.
Is Mama there?
Who?
Mama.
Who's this?
It's Wayne.
Yes, this is Mama, baby.
Mama?
Huh?
I killed Dean.
Wayne?
Ma'am?
What are you doing?
Yeah, yes.
Oh, God. Where are you?
It's all right.
Wayne?
It's all right. It's all right.
Where are you?
I'm out of his warehouse.
Where?
Out at that warehouse he keeps.
Can I come out there?
Yeah, yes. No.
It's on the Highland Park.
She can't. No, you can't come. I'm with the police, Mama.
The prosecution is now preparing its case against Henley and Brooks. Unless the two are adjudged insane, their trial will begin in early 1974, probably in Houston. Because the publicity was so widespread, moving the trial to another Texas city may make finding an impartial jury no easier. The coverage of these mass murders by an aggressive and competitive local press provides a near classic example of the inherent constitutional conflict between the public's right to know and an individual's right to a fair trial by an impartial jury. It is a conflict arising out of a variety of motives. The police's desire to appear efficient, the newsman's desire to scoop the competition, and the public's appetite for gore. All of these motives and more were to be found in Houston in the hot summer of 1973. We will hear first from the three lawyers involved in the case. Charles Melder is defending Elmer Wayne Henley.
The boy was seen on national TV pointing out grave sites. He certainly implicated himself in the murders as far as the TV viewing public, which will make up the jurors. But there's been as much publicity over that in any section of the state as right here in Houston.
Ted Music represents David Brooks.
Well, frankly, at this stage, I think it would be impossible for him to get a fair trial in Texas and perhaps even in the United States.
Dan Lambright is the prosecutor.
Well, I heard a lawyer once say in this very courtroom that it was possible to find 12 people in Harris County who had never even heard of Harris County. I think we can find a jury of 12 people in Harris County to try this case.
I've read too much about it, and I would already be prejudiced. And I don't think I could change my views, you know, and really be objective.
I think you ought to hang them son guns.
Yes, I think they should pay for what they've done. I think people have made up their own minds from what they've read.
I cannot tell if they are guilty or innocent. I don't know all the facts, but it looks likely they are by what I read in the press, that's all.
Jurors tend to do many times what they think the community wants done. And if the hue and cry via the media has been all against the defendants, then the people who are selected to serve on juries have a feeling in the back of their mind, punched into their recorders, that the community wants to stop this sort of thing, that it's a shame and a tragedy, and let's give them a fair trial and hang them.
You have a fine line there between the public's right to know and the defendant's right to a fair trial. I don't know where the line is drawn, especially on a case like this.
I wonder to what extent you could fall if you turned your back entirely upon God. If you denied him, I wonder where you might land and the things that you might do. A 17-year-old boy, just 17 years of age. No one would have ever thought that a 17-year-old boy could have done the things that this 17-year-old boy did.
While the Houston press may have been guilty of an occasional lapse of taste, editors were vulnerable to criticism chiefly for the zeal and number of reporters they poured into the story. We brought a group of these reporters together over beer to talk about the extensive coverage.
The people had a right to know. They wanted to know. You know, and that's where, you know, if you're going to draw any line, that's where you got to start drawing them, you know. Do the people in Houston.
Compelling concern in this community
Correct.
to know,
That's correct.
you know, how in the hell 27 boys had been murdered.
You know, and that's what the deal
It's been 80 years or whatever it is since Jack the Ripper, and that was only 8. And all of a sudden, Houston's got 27. Let's face it, murders are very juicy. They're very interesting. And you've got a story that's breaking and changing by the hour. I think there's an instinct there that, you know, wow, this is a hell of a story. You know, what a story. And that's all you're thinking. It's a hell of a story, and I want these things, and I'm on the phone all the time, and I'm calling this person and that person, and I'm finding this out. And
that's what we're supposed to do in a way. We're supposed to get out there and dig and find, you know, anything we can. But this story was a snap in a way. The only qualification you needed was physical endurance. You had press conferences all the time. You had 2 self-confessed murderers just freely talking to everybody, giving, you know, countless interviews. I mean, you didn't really have to dig that hard on a lot of important issues. But a point comes. What is the news value of this? What is this about? What are we trying to do?
I think there's another point, Susan. All of a sudden, the national attention has come to the provinces. And the story makes the bloodlust run a little stronger, but it's also the fact that this is a shot for us to get national attention. Tom here is writing for the New York Times on a story all of a sudden. I'm feeding CBS News, and everyone else is feeding radio reports to ABC, UPI, whoever is going to take it. And that has to figure in how you cover a story.
Have any of you entertained any doubt as to the guilt of the 2 guys charged in these crimes? I mean, has the thought even entered your mind?
And the media recognizes that propensity in human beings to want to see carnage. And so when they report sensational crimes, they fill in all of the bloody details. And if they can get pictures of the knife or the axe or the mace, they'll sure do it. And if they can get pictures of the hair and scalp on the instrument of death, they'll photograph that blown up, page 1. Depends on whether or not it's, as they call a slow news day, I think.
I report the news, and the news is whatever is happening and whatever I can find out about what's happening.
Well, when you're talking about 27 bodies finally unearthed, the scope of this, it just overwhelms people. 1, 2 cheap killings, forget it. We don't even give them a paragraph. But here you have young boys, tragedy, tears. My God, this whole damn thing went up in the air, and we all got excited about it here.
It doesn't really educate the citizen, does not help track down the criminal. I can visit with them in that area. If it's assisting law enforcement, fine. If it's curtailing crime, fine. But it's not true. It's selling newspapers, and it's selling TV time and radio time, and it's satisfying the lust for gore that I guess everybody has.
Well, that's a lot of crap, because we got a built-in circulation, 300,000. They go to the homes whether we have anything in the paper or not. Oh, but the idea, this is the type of story that the newspaper, I believe, rose to the occasion. Or where they showed the talent, or that the paper reported the story, honestly, a sordid story, but it was told in taste, always.
I don't know how to talk about good taste when you're talking about mass murders, I admit. But I'm saying there's such a thing as news judgment. The map the Chronicle published of the sites where all the bodies were found, just the thing. The family goes out for an afternoon stroll, you know, goes out in the car. We can show little Jimmy, 17 bodies were found here, and show little Susie, 5 bodies were found over there. Is this what the community needs?
The chief justification I find for that, we're frequently accused of running crime stories just for the pure sensationalism. That isn't the case at all. This is one of the facts of life. This is one of the things people need to know about the conditions they live in. How else are they going to order their affairs unless they understand what the situation really is?
I regret that at least one of the local newspapers printed one of the defendant's confessions on its front page. I deeply regret that. A number of the victims who were mentioned in that confession had not yet even been identified by the medical examiner. So the parents of those children got the first word of their children's deaths from that newspaper article. And I don't think it was fair to them, and I certainly don't think it was fair to that defendant whose confession was printed, because in the eyes of the people who read it, he was convicted at that moment.
Asked me, he said, Daddy, he says, you got a birthday coming here in a few weeks. He said, what would you like to have for your birthday? And I just told him, I said, well, son, whatever your little heart desired, it's not the gift, but the thought. And we parted. He said, I love you. And I said, I love you too, son. See you in the morning. He called me later that night. He told me he was going fishing. Some friends of his up to Sam Rayburn.
Jim Lawrence told me that the last word he had from Billy was a letter dated May 6th, but postmarked June 11th, a week after he had disappeared.
February. I'm sorry that I decided to leave, but I had to go. P.S. I'll be back in late August. Hope you understand, but I had to go. Daddy, I hope you know I love you. Your son, Billy.
That was the last you heard from him?
That was the last I've heard from him.
Most reporters spend some part of their career covering crime. Traditionally, that means cultivating policemen. A crime reporter on the outs with the police can scarcely function. In Houston, Behind the Lines, producer Steve Glauber talked with Jack Cato about the relationship between press and police in that city.
The relations here in Houston probably are better than they are any place that I've talked to other reporters about. They all have the same general problems each day covering stories, but this department gets around the closed-door policy that you find in most police departments.
Well, we maintain an office down here, right down at the end of the hall, for them so they can be in this building and so they can report the police news. We think that there's something to be gained from that for the citizens of this city and for the police department. I'm not so much interested in these people just making a living at it. I am interested in the citizens of this city having the facts and the truth about what our operation is. We don't always get it from the local people, but when we don't, we have a little understanding with them or an attempt thereat, and of course we could cut them off at any minute we got ready.
It's very simple. You know, as long as you report what the chief wants you to report, then you're in good shape. You're in good standing, you know, with the department. But the problem is, you know, as soon as you start saying those, as soon as you start questioning, you know, why the blood is on the floor, or why this man, you know, is coming down the hall and he looked all right to you in the elevator downstairs, and by the time he gets to the third floor, you know, he's bloody and stuff, you know. When you report that, then that's when the police department has a problem.
It's not a right that they're enjoying around here. It's a privilege.
And the privilege comes from you?
That's right.
How come?
Because I'm the chief of this department.
But I just thought you were saying that the public has a right to know.
They do.
If you don't like what they report, you're going to kick them out.
No, I didn't say that. I didn't say that at all. If you mean by if they don't report the truth, or if they don't handle themselves, and I don't like it, yes.
Yes, what? Yes, you'll get rid of them.
Yes, I sure will, and have.
Don't the editors complain about it and say, look, you've no right to kick our boy out of here. He's going to stay here and get the news?
No, I run this department here.
Yeah, but you don't run the newspapers.
I don't, well, they can stay over there and get it.
The breaking of prejudicial evidence by the news media feeds appetites of the police, the press, and the public. The police gain credit, the press gets scoops, and the public is relieved of its anxiety about criminals on the loose. In Houston, it's standard practice for the police to parade their suspects before the press.
The name's Junior, not Elmer Wayne Henley.
Well, what?
Get your pictures.
After the news media were led
to a couple of body bags, and it smelled real bad, and you look at the body bag. Then the news media were led to one of the persons who have been accused of this crime. And this person was asked to get out of a car, and he wasn't ordered. On the other hand, the tone of the thing was as if the police department expected him to cooperate with the news media.
We have been accused of staging these, but we don't actually, because it's up to the individual whether or not he wants to be interviewed.
They have a lot of sophisticated ways to exhort, to coerce a confession.
Because of abuses in the past, the courts have restricted the legal use of confessions. Defendants must be warned of their right to remain silent, and even voluntary confessions cannot be introduced in some trials. The reason? Confessions can be extracted in a variety of ways. Attorney Richard Haynes told us how one of his clients was interviewed by police on a rooftop.
To the edge. Of course, you look down as you do off this building, and everybody's got a little bit of the phobia against the heights, and talked a little bit about what would happen to a man if he fell over, how he would splatter and so forth. Well, that the suggestion, very subliminal, of course, was enough to cause that citizen to think that it would be in his best interest to make a confession. Well, without any signs of coercion on the side, he's admitted his guilt, and so even though the niceties of the law have not been followed, there he goes.
A good lawyer will protect his client, of course. He will tell him immediately not to talk. In this particular case, Brooks didn't have a lawyer at the time. Henley didn't have a lawyer. You know, it's open season.
It may be open season for the press, but in the courtroom, the rules are stricter. Excessive pretrial publicity has caused more than one defendant to go free. Still, most journalists insist that the defendant's rights are not their responsibility.
I am not concerned with the legal end of this story whatsoever. Frankly, what happens to the defendants is in the hands of their attorneys and their own consciences. Our responsibility was to tell the story.
I think you have the same problem with this question of a fair trial for a defendant who's done something newsworthy that you would have with a good many other instances I can think of that come to the attention of people in the business of journalism. You simply cannot let your actions or judgments be dictated by what the end result might be after you've reported what you think people are entitled to know.
The key question remains that the people of Harris County had among them a trio of murderers, if we accept the alleged charges. The people of Harris County will probably not have the right to try their people on those charges because the media has created a situation where they can't get a fair trial there. Should the people of Houston be able to try their own people? Did we blow it for the people of Houston?